Stephen, I'm not rewarding you for coming.
Every year, millions of immigrants come to America chasing a dream of opportunity, a dream of a better life, a dream of becoming something more. But what many do not realize is that the journey is filled with confusion, legal traps, and costly mistakes. And that is why this show exists. This is the Immigrant Survivor Show with Dr. Ope Banwo, where we provide information to help immigrants achieve their American immigration dreams without the nightmares. Pay attention as we break it all down for those who have ears to listen.
Let's go, people. Welcome, guys, to day 6 of our 30-day marathon. And I want to welcome Samuel Okpon, one of my paralegal assistants, and Grace Okafor, my other paralegal assistant. Thank you guys so much for keeping the faith and making that promise to be a blessing to the immigrant world in America for 30 straight days, where we come every day and we share with you, we motivate you, we take all the questions you have and try to make it a better time, even though things are tough now, to help you achieve your American dream without the nightmares. Samuel, are you good to go today? I think you should be hosting the show now. You are more handsome than me. You should be doing the show now. You are finer than me now. Grace, what do you think? Should Samuel be hosting this show now?
No, Daddy.
Or maybe you.
No, Daddy first.
As our queen. As our queen on the show. All right, well, thank you guys so much. These are the gentlemen that do all the hard work. They do the research for me, and they make sure I'm on time. They remind me, like today, I almost forgot because there's party everywhere. My niece is graduating today. In fact, the party is supposed to start an hour from now, and you can see I'm dressed. I'm all colorfully dressed to go party. No tie today, and so Samuel is wearing a tie for both of us. Okay, so once you look at Samuel, you know I'm wearing tie too. All right. Okay, as usual, this is our day 6 of the 30-day marathon edition, Immigrant Survivor Show. That's a new show that we are hoping and planning to be a weekly show from July. But for the whole month of June, we are resolved to do the best we can to come to you daily at 4 p.m. Central Time, 5 p.m. New York time, and 10 p.m. West African time. And our main purpose is to come in, motivate you, encourage you as immigrants in America or immigrants coming to America, and more importantly, to take all the questions you may have concerning your own particular situation. So let's go. Well, we always start out, as usual, with what I call my Immigrant Survivor Show rant, the rant of the day. And today, I want to actually talk about something that some may think is no longer happening in America, but I want to reassure them. And I want to talk about America still rewards excellence, regardless of all the tough things that we're going through right now as immigrants. The immigration pathways more immigrants never explore. I'm going to talk about them a little bit before we go into the Q&A proper. America still rewards excellence, regardless of what is going on. And we are going to talk about some of the immigration pathways that some people never explore, or many immigrants never explore, just because they do not know. There was no sound from the intro video. That's an interesting one. Well, we'll keep pushing it. Hopefully, we'll go. But double check that we are live on Instagram, because sometimes this stream here doesn't pick Instagram. And I've activated. Just let me know if we are doing well there. If not, we can always put the recording there later. And if you are watching us from LinkedIn, Facebook, Instagram, Twitter, welcome to the 6th day of the 30-day Immigrant Survivor Marathon that we are doing as part of our launching of our new office in Dallas, Texas, specifically Arlington. We look forward to servicing you in person or nationally through Zoom. All right, let's get to it. Thank you, guys. I'm going to talk you back into the studio and keep helping me make these things happen as we go along. Let's talk about the rant of today and for the show today. America still rewards excellence. Why America still rewards excellence? The immigration pathways most immigrants never explore. Because tonight, I want to challenge something that I hear all the time. Everywhere I go, I hear people saying, America doesn't want immigrants anymore. The doors of America are closed. There are no more opportunities left in America. Let's all go back home. The system is completely broken because Donald Trump wants all of us out. Now, is immigration harder than it was 20 years ago? Absolutely. As enforcement measures increased? Yes, absolutely. Are there more challenges today than there was last year or 2 years ago? Without a question. But tonight, I want to tell you something many people don't realize. America is still rewarding excellence. Don't let anybody tell you otherwise. This is still the greatest country on the face of the earth, regardless of the issues all of us have with it. America is still rewarding excellence. In fact, there are immigration pathways that many immigrants have never even heard of that are still very, very open today. And those pathways are not based on who you know. America doesn't do that. They are not based on luck, not on winning the lottery, even though they still do the lottery every year. Not even necessarily on having family relation members here, even though you can get your papers through family members. They are based on one thing only. What value do you bring to America? You see, when many people think about immigration, they think only about 4 things: marriage, family petitions, asylum, and visa lottery. When you poll most immigrants, that's what they're going to tell you about: marriage, family petitions, asylum, and visa lottery. That's it. But immigration law in America is a lot much more than that. America has always had a place for people who create value, people who solve problems, people who innovate, people who contribute, people who have achieved excellence in their field. That is not changing. Let me give you an example. Many immigrants that I know, including some of the very educated ones, have never heard of something called EB-1A. In simple English, that's an immigration pathway to green card for people and their families who have achieved significant success in their profession. With an EB-1A, not only do you, as the applicant, get a green card, your wife gets a green card, and all your children under 21 get a green card. If you have achieved a significant kind of success in your profession. So scientists, researchers, business leaders, artists, athletes, entrepreneurs, authors, professionals who have distinguished themselves. In fact, what I hear a lot, especially from those who are supposed to know, who have been doing this research, they actually believe that EB-1A is only for researchers. I was told that by a professor just recently, and I had to correct him that no, EB-1A is not just for researchers, that's even EB-1B, the one that is for researchers. EB-1A is for all levels of people who have distinguished themselves in their profession. And this is one of my favorite immigration pathways by far, because to me, EB-1A is the best type of visa you can go for in America of today, because it allows certain professionals and experts to seek permanent residence because their work benefits America. Doctors, engineers, researchers, educators, technology professionals, business innovators, people whose contributions are considered important to the national interest. And guess what? A lot of people are not even looking at it. And then there's the EB2, the national interest waiver. In fact, the EB-1A, you don't even have to show national interest. You just need to show that you have 3 out of 10 criteria as a distinguished person, and you get that. Then we have the EB2, employment-based visa 2, which also allows you, your wife, your family under 21 to get green card. This is also one of my favorite pathways after the EB1A. This EB2 allows certain professionals and experts also to seek permanent residence because their work benefits America. Again, these are doctors, engineers, researchers, educators, technology professionals, business innovators, people whose contributions are considered to be in the national interest. That's the EB2. EB1 people, they're similar, but in their own case, they don't need to show national interest. That is assumed. Because once you can show 3 out of those 10 criteria that they give you for the EB1, then you're solid. To me, EB1A is the best visa in America right now. And very few people are even looking at it. In fact, a lot of people know about EB2. And that's what a lot of our educated professionals are doing. The ones with master's degree, the ones with PhDs, everybody's chasing the EB2 because that's what they know. Or they believe they've allowed themselves to be convinced because of WhatsApp lawyers who will tell them that EB1 is a genius visa, it's only for geniuses. Yeah, they may call it genius visa, but you'll be surprised that a lot of people, at least that's what I found out, a lot of people who qualify for EB1, who qualify for EB2, are also qualified for EB1. But they don't look at the EB1 at all because they are focused on EB2, though EB2 is more difficult to even get than EB1 if you have the criteria. Because the EB1 does not require discretion or national interest. EB2 requires them to be able to say your work is in the national interest. See the difference? So EB1 is cleaner to get. It's more like a checklist. If you can get those criteria, you get it. EB2, on the other hand, you can have all the criteria, but they still have to subject it to national interest. And then that becomes subjective. So those are 2 separate visas that are out there that America still rewards people with. Then there's the O1 visas. Some know about this, but majority do not. This is another pathway based on extraordinary ability and achievement. O1 visa. Now, why am I telling you this? Because the lesson is bigger than immigration. The lesson I'm trying to teach tonight is that America still rewards people who become valuable. Think about that. While many people are spending all their time worrying about policies, worrying about Donald Trump, some immigrants are quietly building their credentials. They're publishing books, starting businesses, creating jobs, getting advanced degrees, speaking at conferences. All of those matter for one of those 3 visas I just mentioned: conducting research, building companies, developing their expertise. And as they become more valuable, new opportunities begin to open for them in America. And that's not just an immigration lesson, that's a life lesson. Because excellence creates options. The more value you bring to the marketplace, the more doors tend to open for you. So don't misunderstand me. I'm not saying everybody qualifies for EB1. I'm not saying everybody qualifies for EB2 national interest waiver. I'm not saying everybody qualifies for the O visa. What I'm saying is that many immigrants dramatically underestimate their own potential. They spend years focusing on what they don't have instead of building what they can become. They focus on obstacles instead of the opportunities. They focus on the limitations in America instead of growth. And that, to me, is a mistake. Because one of the greatest advantages immigrants have is resilience. We are a resilient people. Most immigrants have already done something extraordinary. They left familiarity behind. They adapted to a new country, or they are planning to adapt to a new country. They have learned a new system, or they are planning and ready to learn a new system. Many immigrants, both the ones that are already here in the US or those who are planning to come, they have survived challenges that will have defeated many people. So the question is, what are you going to build on top of that foundation? What skills are you developing? What expertise are you creating? What impact are you making? What value are you bringing? Because it's something I've learned after many years in America, and I've been here now for 31 years. The border may be crowded, but the door to excellence is never crowded. That's why EB1 has never been out of availability. The door to excellence is never crowded. Very few people are willing to do the work required to be exceptional. Very few people are willing to become truly valuable. And that creates the opportunity for the few that do. So tonight, beyond just answering your questions tonight, which I'm going to be doing in a few minutes, I want to encourage you, every immigrant that is watching me right now, don't spend all your time asking how America can help you stay here. Spend some of your time becoming the kind of person America cannot ignore. Build your skills. Build your expertise. Build your reputation, your profession. Build your business. Build your value. Because America may change policies depending on which president or government comes in. Presidents come and go. Congress may argue forever whether to give green card or not give green card. But one thing remains true. Excellence still matters. Achievement still matters. Contribution still matters. And value will forever matter. Think about that. And that's my memo tonight. Now, of course, speaking of opportunities and immigration pathways, when we come back, we're going to be answering all your immigration questions tonight as much as we can during the course of the show. And then we'll discuss the latest immigration developments affecting immigrants all over America. Of course, you are watching the Immigrant Survivor Show with Dr. Ope Banwo. And we are just getting started because this is just day 6 of 30 days of introducing our Dallas office that we recently opened in Arlington, Texas, to you with service clients both locally and globally. So we'll be here every day for 30 days to give you value, to answer all the questions you bring on the show as part of our contribution to the immigrant community, as part of our official launch. Don't go away. When we come back, we will talk about some of the immigration development that happened, maybe some of them in the last 24 hours. You know, things are always happening every day in this country now. You wake up in the morning, something has happened. One memo has come out, and we all have to discuss it. So wait for that. Right after this timeout of, I'm going to show you a couple of educational videos that I believe will even answer the questions some of you already have, even before we start the show tonight. Here it goes. Yes, another question I've been getting a lot lately. I have a criminal record. Sir, can I still become a U.S. citizen? Short answer, sometimes yes, but it depends on the type of your case and your history with immigration. My name is Ope Banwo, and for over 29 years, I've been helping immigrants achieve their American dream without the nightmares. To become a U.S. citizen, you must show something called good moral character. That is where criminal history becomes very important. Some issues may only delay your application. Others can create serious barriers. As always, I like to give a few real-life examples to contextualize this. Scenario: somebody has a single older offense and waits the required number of years. This may still allow them to qualify depending on the facts. Another scenario: someone has a more serious conviction that falls within certain categories. This can create major obstacles or even permanent issues, even though it happened in the past. Or a scenario where somebody has multiple smaller offenses over time. Immigration may look at the pattern and question whether they meet the good moral character requirement or not. Again, the key point is this: having a record does not automatically disqualify you, but it does mean your case must be carefully evaluated before you apply for anything, because applying at the wrong time or with the wrong strategy can do more harm than good. So if you have any criminal history and you are thinking about applying for citizenship, do not assume that you are ready because you have 5 years or whatever. Go to speakwithope.com right now and book a strategy consultation session. Let's talk about this and be sure you are ready.
Speak to me today before your American immigration dream turns into a bitter nightmare.
Immigration Survival Show with attorney Ope Banwo. Wake-up call. Stop making these immigration mistakes. Let me tell you the truth. Most people won't tell you. Immigrants are not just losing their cases because of the system. They're losing because of bad advice, wrong decisions, and dangerous ignorance. And in immigration law, one mistake can cost you everything. This show exists for one reason: helping immigrants achieve the American dream without the nightmares. Pay attention. This could save your future.
Pastors, imams, church workers, there's a U.S. visa specifically designed for you, and many are ignoring it, though they want to come to the U.S. While others are chasing jobs and sponsorships, there's a legal pathway built for people doing genuine religious work who wants to come to America. But because it's not talked about enough, many qualified people never apply. Let me break it down simply for you. There's first the R1 religious worker visa. If you are working as a minister or in a religious role and you have a US-based religious organization willing to sponsor you, then you can live and work in America legally through R1. Secondly, there is the EB4 religious worker green card, and this is where it gets powerful. After qualifying service, you may be able to transition to permanent residency. Now listen carefully. This is not for people looking for shortcuts. You must show genuine religious work, consistent involvement in ministry, and a real organizational structure for your church. The mistake many people make is trying to package it like a business opportunity. No, it's not a business opportunity. Immigration is looking for authenticity, not strategic games. So if you are truly doing the work, you may already qualify for a legal pathway into the U.S. as a minister or as a religious worker. But let's find out. Go to speakwithope.com, book an appointment, and let's review your qualifications for this opportunity. Because when your purpose is clear, your pathway can be too. Just check it out. My name is Ope Banwo, and they call me the Immigration Rottweiler. Not because I bark, not because I make noise, but because I don't let go. When your case gets tough, when the system pushes back, when others start telling you there is nothing we can do, that's when you call me. Because once I lock into your case, I don't stop, I don't quit, and I don't back down until we get results. So go book a consultation on speakwithope.com now, and let's activate the Rottweiler mode on your case before the immigration knocks on your door.
Awesome. Hopefully you guys are having some fun enjoying Immigration Survival Show with Ope Banwo tonight. And now we want to look at some of the immigration updates that showed up in the last few days, maybe that we haven't talked about in a couple of days that we have been doing this. I want to talk about the immigration update where we're hearing that immigration may reduce, that they may reduce processing locations in Africa. They're proposing to reduce U.S. embassies and consulates processing applications in Africa from 50 locations to 20. Basically, they are reducing it by more than 50% because they say this is part of a broader effort to strengthen visa screening. I don't understand how that could strengthen visa screening. They say they want to use it to reduce visa overstays and to tighten immigration controls. That's literally, that's the excuse they gave, that they're reducing from 50 locations to 20. Why does this matter? If implemented, this could have significant impact on immigrants, students, visitors, workers, and family-based applicants all over Africa. Because some of the consequences we may have to deal with, obviously, longer wait times. You think times are long now, it's probably going to be longer. There's going to be increased travel costs for applicants who may need to travel to another country for their interview. They even listed the countries they're going to keep. And I think Nigeria is actually one of them. Thank God. That means they're probably going to leave the band very soon. Okay. Delays in family reunification cases is going to cause delays. It's going to be that you're going to have longer processing times for immigrants and non-immigrant visas. Obviously, with fewer locations, there's going to be increased competition for available interview appointments. So it's really brutal. I have to be honest about that. So for many African applicants, access to visa services may become more difficult and more expensive. It's just a reality that I need to prepare you for. Now, this development does not mean visas are ending. Let's not start carrying rumor. And it does not mean applicants will automatically be denied. That's not true. However, it could mean that visa processing will become slower and more centralized. So individuals with pending immigrant visa cases, family petitions, student visas, work visas, or visitors visas should be prepared for potential scheduling delays and changes in interview locations. So here's my advice. If you're eligible to begin a visa process, do not unnecessarily delay your filing now. You need to monitor your embassy or consulate's announcement regularly because they will let you know when they're shutting down. Plan ahead for possible travel if your visa is transferred to another processing location, because they shut down the one in your country, obviously they're going to give you another country to go. So the take-home message here is today's update is not about eligibility, this particular one. It's about visa access. Even qualified applicants could face additional delays if fewer embassies are handling interviews. So the immigrants who will be least affected are those who prepare early, those who submit complete applications, those who monitor their cases closely and stay informed about changes in embassy operations. So you gotta keep on top of this thing. So, but here's what I have to say to conclude this part. Immigration opportunities are not only affected by the law anymore, they are also affected by access to the process. When interview locations become fewer, preparation becomes even more important. You're probably going to get only one bite at the apple. And the best time to prepare your immigration case is before this bottleneck starts, not after you are stuck in it. Those who have ears, let them listen. Here is another update I'd like to discuss for today. Immigration judge, I know that has been all over the place yesterday. An immigration judge actually made a ruling where it blocked the restrictions that have been affecting nationals of the 39 banned countries, which include, of course, my own country of birth, Nigeria. So in a significant ruling, a federal judge, not a state judge, a federal judge has blocked the restrictions imposed by the Trump administration that affected immigrants from 39 countries in Africa, Asia, Latin America, and the Middle East. These restrictions that they put in for those who have been affected, it placed holds on various immigration benefits, including asylum applications were not getting approved, work permits were being put on hold, green card processing, and citizenship applications, even for those who are in the US. As a result, many immigrants were left waiting for months without any legal status. I'm talking about those who are even here. They're not getting the employment authorization, and they're not getting clarity about their future. And the court just ruled that government's actions were unlawful and found that many immigrants were being affected simply because of their country of birth rather than their individual circumstances, and that is not permissible according to the judge. So the judge has ordered the restrictions to be halted, making it a major legal setback for the administration on immigration policies. Now, this ruling is very important. You might ask yourself, why does it matter? It's very important because it could reopen opportunities for thousands of immigrants whose cases were delayed, frozen, or placed on hold. For many of the people who have been affected, this may mean now they're going to resume or the resumption of pending immigration applications, possible movement on delayed work permit applications that have been stuck for months, where many even have to stop working. Because once your work permit expires, employers are no longer allowing people to keep working because they don't want to be fined. So I know a lot of people who are waiting for their work permit, and because it has not come in 120 days, 90 days, the employer told them to stay at home once that their work permit expires. But this ruling could start to change that. That we could also start seeing progress on green card and citizenship applications that have been submitted. And now people will have better certainty about their immigration status. Most importantly, this ruling reinforces the principle that immigration benefits should be adjudicated based on the law and individual eligibility, not based on somebody's nationality. Now, we don't know if the Trump administration is going to appeal this. They have the habit of appealing every decision that goes against them, and maybe they're going to appeal straight to the Supreme Court, and then the Supreme Court will have to make a final ruling. But today's ruling, or yesterday's ruling, serves as a reminder that immigration policies can change, but courts remain an important check on government action. Thank God for that. American courts are still standing up for the immigrants. Many immigrants lost hope when their cases were frozen, and many of us, even lawyers, who became helpless to help them because this frozen is frozen. We can't unfreeze it, but we keep getting letters back that are based on presidential proclamation. But this decision now shows that legal challenges can change the course of immigration policy and potentially restore opportunities that appear to have been lost. So just because your case has been delayed does not mean your future has been denied. In U.S. immigration law today, today's setback can become tomorrow's opportunity. So stay informed, stay prepared, and never assume that government's policy is the final chapter of your immigration story. That's what I tell my clients when I encourage them. No, it doesn't mean the end. It simply means that they've done their worst for today. As we say in Nigeria, okay, the wicked have done their worst. It doesn't mean tomorrow will not be another day for you. So keep your head up and keep being optimistic. We are hoping that the administration will just take it in good faith and reopen all those paused cases and not just appeal it to the Supreme Court as a way to keep doing whatever it is they are doing. And this is where you want to subscribe to my free newsletter. Where is the link for that? Because as soon as these things come out, I send out a press release, or I send out a newsletter to my subscribers. It is 100% free, the Banwo Immigration Newsletter. And you can subscribe at banwolaw.net/newsletter. banwolaw.net/newsletter, so that you can get immediate access to weekly immigration updates, breaking USCIS news, visa bulletin alerts, green cards and citizenship questions and solutions, tips and all that. You can get access to that when you join that that newsletter. All right, those are all the updates I have for you tonight. I want to celebrate those of you who are already interacting with us on the charts. I see Ope Banwo here. Let me put up his comment. This new court judgment in favor of countries under the ban list. Can you, Embassy Nigeria, recognize this judgment to review or reopen an immigrant visa on hold at the final stage of approval just because of presidential proclamation against country like Nigeria? Yeah, we are going to see, when a decision comes out like that, there's not going to be implementation guideline. So I don't want to raise alarm and I don't want to raise people's hopes too much, just in case this is not as breakthrough as we are all thinking it is, because the Trump government may choose that they want to appeal it, in which case status quo remains while they're appealing it. They could come up with rules and say it only applies to those who are in the U.S. not those who are outside the country. So we are going to be getting clarity, Mr. Taiwo, we're going to be getting clarity about this over the next few days. This decision just came down yesterday. So please subscribe to our newsletter so that you can be informed as these things develop. Things are always developing on a daily basis on a daily basis. Okay, so let's go to the Q&A for today. Let's take your questions in the order that we receive them so that we can educate while at the same time giving you almost a free consultation for as part of our new office that opened up in Arlington, Texas. Okay, but I want to preface everything I'm going to be saying that there is no attorney-client relationship concerning everything I'm going to be saying tonight in answering your questions. I'm just giving general legal advice. I encourage you, before you act on anything that I've said, make sure you talk to an immigration lawyer. Don't say tomorrow, I had it on Banwo Law Show, so therefore, because your facts might be different. Facts are very important in immigration, so I want to put a disclaimer out there like that. I'm just giving general information. For the specificity of that thing to your personal situation, I encourage you to get your own immigration attorney. Having said that, let's look at what we got. Okay, the first question they've sent to me here is, I'm a U.S. citizen sponsoring parents for green cards through consular processing. They have visitor visas and plan to visit soon. Should I file now or wait until after their trip? Very good question. This is a very common question that we get. And the answer is yes, you can file now, but that may not necessarily be the best strategy. The fact that you can do something, I try to teach even my staff that all the time, that the fact that you can do something or allowed to do something does not mean you should do it. Everything is permissible, but not everything is expedient. So that may not be the best strategy for you to just go and file for them right now. Because as a U.S. citizen, once you're over 21, you are allowed to file I-130 petitions for your parents at any time. There is no law that says you must wait until after they have visited America. However, because your parents are planning to come to the U.S. on visitor visas, I would generally advise that you wait until after their trip if the visit is already scheduled or maybe it's coming soon. And here's why. Because once you file that I-130, you have officially started the immigration process. That doesn't cancel their visitor's visa, especially if you didn't put the other applications in there, just the one I-130. But it does show immigrant intent. It already shows that they are planning to come to America and stay forever, because that's what the I-130 is, to become green card holders here. So when they arrive at the airport, the border patrol officers may ask additional questions about whether they truly intend to visit temporarily and return home, or whether they are planning to stay here permanently, in which case they may not let them come in. Since your plan is to do consular processing for them, the cleaner approach, in my own opinion, is number one, let your parents visit the U.S. first before you file anything. Let them return home as planned, since they really just wanted to come and visit right now, according to you. Then file the I-130 petition after they have returned back home. And then you can then complete the immigrant visa processing through the U.S. consulate abroad. That will be a cleaner, less story for you. Because though you can also file adjustment of status for them when they come in here, but that could lead to some questions. Now, if there's an urgent reason to start the process immediately, filing now, like I said before, is legally permissible. Just make sure your parents are prepared to demonstrate when they come in on that temporary visit. They must have documents to show they're visiting temporarily. They must have good explanation. They must have their return tickets back to their country of origin. They must be able to show ties to the home country. and they need to be able to show them or convince them that they intend to complete their green card process abroad, that they are not trying to obstacle this process by coming with the visitors team so that they can try to complete the process here. So my practical advice as a lawyer is that if the trip is only a few weeks away or months away, let them take the trip first, and then you start the immigration process after they have gone back. It is often the smoother path and helps you avoid unnecessary scrutiny at the point of entry. Of course, when they're already here, if you then choose to file adjustment of status for them to change their status to green card while they're here, provided they don't really have to go back quickly, of course, it's also something you can do. But again, those questions we keep recurring. Hopefully, that is helpful to you. Hopefully, you can do something with that advice. Now, let's look at the next question. It says, I have an H-1B extension that was approved effective October 1st, but I'm traveling in July. I may not receive the new I-797A before departure. Can I re-enter using my current H-1B, and will it affect my extension? Well, that's a great question, and it's one that creates a lot of anxiety for H-1B holders. Based on the facts that you have shared, your current H-1B visa stamp and your current H-1B approval, they remain valid until September 30th. So since you are leaving on July and returning on July 1st and returning on, I think, I don't know, when you are returning, hopefully it's within 30 days, you are seeking re-entry while your current H-1B is still valid. So generally speaking, re-entering the US before September 30th using your H-1B visa and current approval notice should not automatically invalidate your separately approved H-1B extension, the one that becomes effective October 1st. But if possible, travel with your current I-797 approval notice, your passport, your visa stamp, your recent employment verification letter, and any copy of the new approval notice that your attorney can provide for you for the trip. One thing I always tell my clients is this: after you return to the US, you want to immediately check your electronic, the CBP website for your electronic I-94 record so that you can confirm that your information is accurate. Sometimes while you're coming back in, the officer at the point of entry could make a mistake in classifying you, which could become a big problem later. I've seen a few of that. Is why I also advise my clients now, don't assume that officer put the correct classification for you. You want to check their system, see the classification they gave you, because if there's a problem, so that you can start solving it before maybe you're trying to apply for green card or trying to change to something else, in which case that can derail it and cost you months and years of pain. As always, because travel can have a specific case consequence, especially when a new approval has recently been issued in your own case, I strongly recommend reviewing your plans with your employer's immigration attorney, if your employer has one. Most employers who do H-1B now, they have an immigration attorney that work with them. Make sure you have a meeting with him before you leave. So basically, based on the information you have given me, your travel should not automatically cancel or invalidate your October 1 H-1B extension, but make sure that you carry proper documentation and verify your I-94 after you have re-entered. That's assuming that you really have to go. If you don't have to go, my advice, don't go nowhere. Okay. Hopefully, that gives you some clarity a little bit on what you're trying to do. Okay, let's look at question 3 here. a friend was detained at LAX. Okay, it was denied entry, at LAX, and detained by Custom and Border Patrol despite having a valid B1, B2 visa. Could alleged unauthorized work during a prior visit be the reason? This is from Sammy in Chicago. Well, this is a very serious situation. And yes, based on the facts that I have described, unauthorized employment could absolutely be a factor because they are preventing a lot of people who have had unauthorized employment from coming back into the country now. A B1, B2 visitor visa is intended only for tourism, family visit, and certain business activities or maybe medical treatment. It does not authorize employment in the US. So if the CBP officers determine that your friend worked while on a visitor's visa, even if it was paid in cash and worked only briefly, they could continue, or rather they could conclude that he has violated the terms of his visitor's visa, and then they will refuse him entry. What a lot of people may not realize is that CBP officers, that is that Custom Border Patrol guy, have broad authority at the point of entry. So having a valid visa, a lot of people are finding out, does not guarantee you admission into the US anymore. The visa only allows a person to travel to a US port of entry. And by the way, it has never guaranteed, it's just that there's not too many people being sent back before. So the law really didn't change. They are just enforcing the law better now. Donald Trump did not pass the law. There was no new law about this. The law has always been there, even before I became an immigration lawyer 29 years ago, which is having a valid visa does not guarantee you entry into the US. The visa only allows that person to travel to the US port of entry, whether by land, by sea, or by air, and request admission. But the border patrol guy, the Custom and Border people, they make the final decision. So if the CBP officer believes someone previously worked without authorization, or misrepresented their intentions, or maybe they are likely to violate their status again based on the story they tell, they may deny them admission and place that person in expedited removal proceedings. Is that crazy? As for your friend being here for several days, that can happen while the CBP completes its investigation. Maybe they want to conduct interviews of other people, they want to prepare paperwork, or they want to coordinate travel arrangements. And during that time, access to phones and communications is often limited, obviously for security reasons. So the consequences can be significant. Depending on what they found, your friend could have his visa cancelled and may face a bar from returning to the US for a period of time. The exact consequences depend on what the Border Patrol people found, whether they found a simple visa violation, maybe they found misrepresentation, or maybe they found another ground of inadmissibility. That's what's going to determine the fate of your guy. So the takeaway here for this person and anybody listening right now is that a valid visa is not a guarantee of entry to the US. If the CBP border people discovers evidence of unauthorized employment or believes that a traveler intends to violate the terms of their visa, they can deny admission, they can cancel the visa, and they will place the person on a return flight back home. It's happening a lot. Anyone facing this situation should obtain copies of their CBP paperwork as soon as possible. Excuse me. Get copies of your paperwork as soon as possible and consult an immigration attorney so that you can understand the long-term impact on your future travel and immigration benefits. It doesn't end there, even they send you back. There's a lot of other stuff that could be affected. So you need to pay special attention to that. Hopefully, that also gives you some comfort or some direction. I want to appreciate every one of you on this call right now. And you are live with Ope Banwo on Immigration Survival Show. It's our new show, the Immigrant Survival Show. We're on day 6 of our 30-day marathon edition, which is to introduce the show and also to celebrate the opening of our new office in Arlington, in the Dallas Metroplex area of Texas. And you can also, of course, will represent immigrants all over the nation. Or if you are close by, you may want to step into our office. We have cookies all month long, and we have free drinks just to celebrate our opening our new office here. When I come back, we take some more questions. Right now, I want to take a little break so that I can drink some water and show you more instructive videos. These videos sometimes are much more powerful than me even answering questions live for you. I'll be right back. Don't go away.
If you're already in the US, you may have a legal pathway to becoming a permanent resident and not even know it. My name is Ope Banwo, and for over 29 years, I've been helping immigrants achieve their American immigration dreams without the nightmares. Every week, I meet people who think they're stuck. No papers, no options, no future. But the truth is, they just don't understand the system. Let me give you 3 powerful pathways that people often overlook. Number 1, asylum. If you have a genuine fear of persecution in your home country, you may qualify to stay and eventually get a green card here if you can document it properly with an attorney who knows what he's doing. Number 2, adjustment of status. Some people enter legally and later qualify through marriage, employment, or other categories, but they don't take action on time. Number 3, special protection programs like VAWA, U-Visa, SIJS. These are designed to protect victims and vulnerable individuals. And many people qualify, never apply because they don't even know these options exist. So listen carefully. Immigration law is not always about starting from outside. Sometimes your opportunity is already inside your situation. So before you give up or assume it's over, you may just be one strategy away from fixing your status. So go to speakwithope.com right now, book a consultation appointment, and let's review your case properly. Because in U.S. immigration, what you don't know can cost you everything. Let's talk. I got this one still on the criminal record thing. It says, I have a green card and a past criminal record. Can I still travel freely? Short answer, not always. You could still face problems when you try to come back into the country. My name is Ope Banwo, and for over 29 years, I've been helping immigrants achieve the American dream without the nightmares. A green card gives you the right to live and work in the U.S., no doubt, but it does not give you complete protection, especially when you travel outside the country and are trying to come back. When you leave the country and try to return, immigration officers can now review your record again, and certain issues can turn a simple trip into a serious problem at the airport on your return. Here are a few real-life examples. A green card holder with a past drug-related offense traveled abroad and is stopped at the airport when trying to enter. And before you know it, he was in deportation proceedings. Another scenario, a person with a theft or fraud-related convictions leaves the U.S. for a short trip to bury the parent, and on return is placed into secondary inspection on return. Now they are trying to activate deportation proceedings based on that fraud-related conviction, even though he has a green card now. Another scenario, someone with multiple arrests, some of them even older than 15 years, traveled abroad without checking their record or speaking to a lawyer, and ends up facing questions and deportation proceedings at the border on the return. The key point is this, as always. Travel for a green card holder is not just travel anymore. It is re-entry. And re-entry means inspection. If you have any criminal history, even if it says minor or old, you should not travel blindly. I'm not saying don't travel, but one trip out could create a problem coming back in. So if you're a green card holder with a record, criminal record, and you're planning to travel, make sure you understand your risk and what to do first before you go. Please go to speakwithope.com and book a strategy consultation session with me right now. Talk to me today before your American immigration dream turns into a nightmare.
All right, welcome back to Immigrant Survivor Show with Dr. Ope Banwo, and I have with me in the studio three of my special assistants, Mr. Samuel Okmon, Stephen Oyile, and of course Grace in the studio with me tonight. And we are taking your questions. If you have any questions for us, please post it on the chat, because we are celebrating you as the immigrant as well as ourselves all month long with our new office that we just opened in Arlington, Dallas, Texas. Here's the next question that we have. This person didn't put their name. Say, my girlfriend received a 5-year removal order after the CBP found marijuana in her car at the border, though she claims it really wasn't hers. Can the ban be shortened? And if a student visa or marriage-based visa waiver, the better option. And it's a student visa or marriage-based waiver, the better option. Okay? Well, this is a difficult situation, as you already probably guessed. But it's important to understand that when someone arrives at the U.S. point of entry, that's with the CBP, they can hold them responsible for items that are found in their vehicle, even if they claim they don't know anything or they don't know that the items were present. You are responsible for what's in your package. So based on the facts that you have described, your girlfriend appears to have received an an expedited removal order and a 5-year ban to re-entry. Yeah, that's what you said. So unfortunately, a negative drug test does not necessarily resolve this issue, even if she tested negative for drugs, because CBP's concern may be possession or admissibility, not whether she personally consumed the marijuana. So the first step is to obtain and carefully review all the records of immigration, the CBP that she has, and the paperwork that she was given to determine the exact ground of inadmissibility. They will have given her a paper that showed the ground of inadmissibility that was applied to her. So your strategy probably would depend heavily on whether the issue was treated as a simple possession, a controlled substance violation, which is totally different, or misrepresentation. Maybe they're getting on the fact that she lied or she told them she didn't, she's not the owner, or maybe another ground of inadmissibility entirely. There's so many grounds of inadmissibility that they could have applied. They could have said she was inadmissible because she had a simple possession of marijuana. They could have said she has a possession of controlled substance. They could have said it represented a luggage to us. Each one of those three things have a whole different strategic approach to it. Some may still be able to help you to keep your green card. The other one, you get a permanent bar. So, and the ground for which you are excluded will have been included in the documentation that she was given. So now let's talk about some of the options you mentioned in your question, like the student visa. See, a student visa application is probably possible for the future, but a prior expedited removal like she got and a 5-year bar will create significant obstacles. So simply applying for a new visa does not automatically solve your problem. It doesn't remove or eliminate the removal order or the bar. You talk about marriage also. Getting married to an American, okay, a marriage-based immigration case may provide a path forward if the relationship is genuine and the parties are otherwise eligible. I grant you that. However, depending on the specific inadmissibility finding, you probably will need waivers. And processing of that can take reasonable time. As for shortening the 5-year bar, based on your question again, there are probably limited options. I don't know. In some situations, individuals may seek permission to reapply for admission before the bar expires. But eligibility depends on the specific facts of the case and the legal basis of requesting for them to shorten the time, which is what your lawyer is going to be doing for you. If I were evaluating this case, I will focus first on obtaining the complete CBP file and identifying the exact statutory grounds that was used by the officer. Immigration is not sentiment. What grounds were used by the officer when they excluded your girlfriend? That information is critical before any smart person can decide whether a student's visa strategy, a waiver application, or a family-based immigration route offers the best chance of success. If anybody is giving advice without seeing all the entire documentation in the file, they are deceiving you and they're about to set you up for serious pain. So the takeaway here is that the key issue is not whether the marijuana belonged to her. It is how CBP legally classified that incident. So before pursuing any immigration benefit, she should have an experienced immigration lawyer review all these documents of removal that she was given and determine the precise inadmissibility grounds, because that is what is going to largely determine which options are realistically available or which other one are just talking English, and how long the process will take. I hope you get this, because this is a drug-related issues are not fun. And guess what, guys? It's already 1 hour. I promise that we're only going to do 1 hour today, Saturday, and 1 hour tomorrow, before we revert back to 2 hours on Monday. So that's all we can take for today. I want to, again, appreciate everybody. I have to leave for my niece's graduation. Started like 23 minutes ago. I know they're going to be waiting for me. And everywhere in Dallas is far. Okay? It's about 1 hour to get to where they are from where I am right now. So we have to cut short today, and we've done the 1 hour with you. And I look forward to seeing every one of you tomorrow. Again, share the link with your friends. Let them bring their questions. Let's have a profitable discussion with them. At least, even they're not calling immigration lawyer yet, at least they can get answers to all their questions for free on this show. And of course, we'll also be discussing immigration developments, the updates. You wake up every day, there's something new that is happening, and you want to keep track of all of that. We help you keep track of all of that. So thank you so much for being part of our show tonight. I will see you same time tomorrow, 4 p.m. Central, 5 p.m. New York time, 10 p.m. West African time. Stay blessed. Let's go have some fun. It's Saturday. Go out there and have some fun. And Dr.